All right, let's go. The coffee in front of you has gone cold, and you haven't touched it, because the man sitting across the table just said your name in a way that meant something different than it did yesterday. 10. The morning the lawyers stopped returning calls. You are in a booth at the back of a restaurant on Mulberry Street, Lower Manhattan, sometime in the late autumn of 1985, and the booth is the same booth it has always been, the one with the torn red vinyl on the left side that nobody ever fixed because fixing it would mean acknowledging it existed, which was not how things worked here. The restaurant is not open yet. It is 7:40 in the morning. There are three of you. The man to your right is eating eggs. The man across from you is reading a newspaper, which is a thing he does not actually do, and the newspaper is yesterday's. The reason you are here this early, before the street has any noise in it, is that your attorney, the one on retainer, the one who has answered every call for 11 years, did not answer last night. He did not answer this morning. His office opened at 8, and the woman who answered said he was unavailable in a tone that meant something more than unavailable. The Colombo and Genovese families both have men in rooms this morning doing the same arithmetic. The FBI has been building the RICO case that will become United States v. Salerno for the better part of 3 years, and what the men in your organization have begun to understand, not from official channels, but from the way certain conversations stop when certain people enter rooms, is that the indictments are not hypothetical anymore. The lawyer's silence is the first concrete data point. It means he has been contacted. It means he has been offered something. It means the document with your name on it already exists somewhere in a federal building 4 blocks south of City Hall, and it has been signed. The newspapers that morning ran nothing. The FBI's internal communication, later declassified, noted that surveillance teams had been running continuous coverage on 6 locations simultaneously for 72 hours, and that subjects were displaying, in the language of the field report, no unusual departure from established behavioral patterns, which was accurate. You were eating breakfast in the usual place. The man reading the newspaper was reading the newspaper. Nothing about the morning was unusual except the thing nobody mentioned, which was that the lawyer had not called back. The case was formally announced on February 26, 1985, when 8 men, among them the bosses of the 5 New York families, were indicted on RICO charges arising from their alleged membership in a national criminal commission. The charges included labor racketeering, extortion, and conspiracy. The press office of the United States Attorney for the Southern District issued a prepared statement describing the arrests as the result of, quote, a sustained and methodical investigative effort. The statement named the defendants. It did not name the informants. It did not name the specific surveillance locations. It did not explain how the government had obtained recordings made inside rooms that were swept for devices twice a week. But the thing that doesn't close is this. The government's account of how those recordings were obtained was contested in pretrial motions by 4 separate defense teams, each working independently, each arriving at the same procedural question. The warrant applications referenced a source whose identity was sealed under a provision that, at the time of filing, did not technically exist in the statute being cited. The judge ruled it admissible. The recording stood. The source was never identified in open court. And in the years since, the legal mechanism used to seal that identity has been cited in 41 subsequent federal cases in 3 circuits, each time without the underlying question being re-examined. 9. What it costs to sit in that chair. The chair you sit in, not a metaphor, an actual chair, a specific one, in a specific room on a specific block in Brooklyn that changed addresses twice in 4 years, weighs nothing. That is the first thing you notice. You expected it to feel different. Every man who sat in it before you had a quality about him, a density, the sense that he occupied more space than his body actually required, and you assumed that was the chair doing it. It is not the chair. The chair is just a chair. The weight is something you bring to it, and the morning they put you in it, you do not yet have enough weight, and the men sitting in front of you can see that, and they are waiting to see if that changes. Being an underboss in the Genovese family during the commission trial period meant managing a structure that ran from the street level, numbers runners, loan accounts, labor delegates, up through capos who each controlled between 8 and 25 men, and then to you, and then above you to a boss who by the mid-80s had learned to make himself so procedurally distant from any specific order that his name appeared in none of the wire transcripts that mattered. Your job was to be the name that did appear, not in writing, never in writing, but in rooms, in the specific look exchanged between a capo and a made man when a question needed to go up the chain. Your name was the answer to the question, who do I call? You were the last man before the man who couldn't be reached. What the FBI surveillance logs showed and what was entered into the trial record was a pattern of meetings rotating locations, never more than 4 men, always in businesses that had legitimate noise. A refrigeration unit running, a kitchen, a radio left on. The logs show the pattern. They show who entered and who left. They show duration. What they do not show, because the recordings were not always clean, is what was decided. The transcripts contain, in the agent's own notation, 17 instances of the phrase "content unclear," or voices obstructed at moments that the defense later argued were the only moments that mattered. The role of underboss was not formally acknowledged at trial. No defendant stipulated to organizational rank. The government established hierarchy through testimony and through a series of surveillance photographs taken over 14 months, in which the same men appeared in the same relational geometry, who sat, who stood, who spoke first, who waited across dozens of separate locations. The jury was instructed to draw reasonable inferences from pattern evidence. They did. And yet, the thing the pattern evidence cannot resolve is the texture of what that role required day to day, the specific human cost of being the man who absorbed the consequences of decisions made above him and deflected the consequences of decisions made below. The role is described in indictments and sentencing memos with the language of command and control. It was also, to the men who held it, the role most likely to produce a specific kind of silence. The kind where you stop asking certain questions because you already know the answer, and the answer requires you to do something, and doing something requires you to be the kind of person you are no longer sure you are. 8. The night they played the tapes. The room where the tapes were first played back to the defense teams was on the 14th floor of a federal building, and it smelled like the heating system had not been serviced since the building was constructed. And there were 7 attorneys in the room and 2 government representatives, and a technician operating a reel-to-reel unit that was, by 1985, already slightly antiquated. You were not in that room. But within 48 hours, everything said in that room reached you, and what reached you first was not a legal analysis. It was a single sentence from your own attorney, delivered standing in the hallway outside his office, not inside it, because inside it he was no longer certain was safe. They have the room on Grand Street. The room on Grand Street was a social club with a linoleum floor and a television that received 4 channels and a back room where, on the first Tuesday of each month for approximately 6 years, men sat and discussed things that were never supposed to leave the room. The FBI had placed a listening device in the room, in a location that was not discovered during any of the sweeps conducted between 1981 and 1984. The device recorded approximately 240 hours of audio before it was removed, not by the organization, but by the agents who placed it, because they had what they needed. The recordings included voices that could be identified. They included discussions of specific events. They included, according to later legal filings, at least one conversation in which organizational hierarchy was discussed with a degree of candor that the men in the room would not have used if they had known what was in the wall. The newspapers reported the existence of the surveillance recordings in a story that ran 3 days after the indictments, citing unnamed federal officials. The story described the recordings as extensive and significant. It did not describe their content. The FBI's public statement confirmed that electronic surveillance had been employed in accordance with all applicable legal requirements and pursuant to duly authorized court orders. What the statement did not address was the timeline. Specifically, that the warrant authorizing the Grand Street device had been applied for and granted within a 72-hour window that coincided with a date on which one of the men in the room had met, at a location not otherwise under surveillance, with a federal contact whose existence was never part of the public record. The legal resolution of the tape evidence consumed 2 years of pretrial litigation. Motions to suppress were filed, argued, and denied. The recordings were authenticated by voice analysis conducted by an FBI laboratory. The chain of custody was established through testimony. The device's placement was explained through the authorized warrant. Everything was in order. The order was complete. But the Grand Street room was swept 6 times between the device's installation and its removal. 3 of those sweeps were conducted by a security contractor whose principal had, according to documents produced in a separate civil matter 11 years later, a prior business relationship with a man who worked as a technical consultant for the FBI's organized crime unit. The relationship was not concealed. It appeared in corporate filings. It was simply never introduced into any proceeding where it would have been relevant. You have been in rooms like this longer than you realize. The next entry is where that starts to mean something you cannot walk back from. 7. The man who knew too much about what he didn't know. His name was Angelo Lonardo. He was, in 1983, the acting boss of the Cleveland crime family, a man in his late 60s who had survived more internal reorganizations than most men in his position survive, and who had, by the time you heard his name in a context that mattered, already made a decision so large that the people around him had not yet registered what it meant. He had decided to cooperate. Not in a panicked way, not in the way of a man who breaks under pressure in a single afternoon. He had decided the way men decide things when they have had time to sit with the weight of a life sentence and come to a conclusion that is, from a certain angle, entirely rational. You heard his name at a table in Queens, from a man who had just come back from a trip to see people in Cleveland, and the way the name landed told you everything. Lonardo's cooperation produced something specific and procedurally significant. He could speak to the existence and function of the Commission, the governing body of the American organized crime families, from a position of direct, experienced knowledge. He had attended meetings. He had represented Cleveland's interests. He knew the structure not as an outsider guessing at it but as a participant in it. His testimony, delivered in 1987, would become one of the foundational pillars of the government's case, not because he provided new information that the FBI hadn't already collected through other means, but because he could put a human voice to the architecture. He could say, "I was in the room. Here is what happened in the room. Here is who sat where." The press reported Lonardo's cooperation when it became public through court filings, describing him as the highest-ranking organized crime figure to turn government witness at that point in American prosecutorial history. The FBI's subsequent memos described his cooperation as, quote, forthcoming and consistent across multiple debriefing sessions. What the public reporting did not capture, because it occurred in sealed proceedings, was the negotiation. What was offered, what was asked for, what version of events was agreed upon before any of it was spoken in open court. Lonardo received a reduced sentence. The cooperation agreement was standard in its broad architecture. The terms were sealed. The official record reflects a witness who provided substantial assistance in accordance with the agreement's requirements and whose testimony was found credible by the jury. And yet, the thing his cooperation cannot resolve, not his testimony, not the agreement, not the jury's verdict, is the question of what he chose not to say. Cooperation agreements are not compulsory truth-telling instruments. They require substantial assistance. They do not require complete disclosure. Every man who has sat across from a federal prosecutor and agreed to cooperate has made, somewhere in that conversation, a decision about what stays in the room. Lonardo's sealed agreement runs to 43 pages. The portions that remain sealed include, according to the docket notation, material pertaining to ongoing investigations. Those investigations, as of the last public docket entry in the relevant case file, have not been formally closed. 6. How a trial changes the air in a room. By the time the trial itself began in September 1986, in the courtroom of Judge Richard Owen on the third floor of the federal courthouse in Lower Manhattan, the air in every room connected to the case had a quality to it that is difficult to describe with precision, but that every man who experienced it would recognize immediately. It was the air of something already decided, not in a conspiratorial sense, in a mechanical sense. The machinery had been running too long, too completely, with too many moving parts all synchronized in the same direction, and what you felt in that air was not injustice and not certainty. It was the specific weight of a process that has achieved enough momentum that the outcome is not yet fixed, but the range of possible outcomes has narrowed to something you can fit in your hands. The defendants were 8 men: Anthony Salerno of the Genovese family, Carmine Persico of the Colombo family, Anthony Corallo of the Lucchese family, and 5 others whose names appeared in every document and whose faces appeared in every surveillance photograph. Their attorneys were some of the most experienced criminal defense lawyers in the country. The trial ran for 9 weeks. The government called 21 witnesses, including Lonardo, including FBI agents who had conducted the surveillance, including technical experts on the recording equipment, including a former organized crime figure who had been cooperating with the government for several years, and whose identity had been protected through a series of procedural maneuvers that were, in the trial record, described only as appropriate protective measures. The total volume of evidence entered was sufficient to fill, according to the court clerk's log, 11 bankers' boxes. The newspapers covered the trial daily for the first 2 weeks and then intermittently, as trials longer than a news cycle tend to be covered, in bursts, around testimony days that were flagged in advance as significant. The reporting was accurate to the public record. It reflected what was said in open court. The FBI's media liaison issued no additional statements during the trial period. What the reporting did not reflect, because it occurred in sealed sidebar conferences and in chambers meetings that were not transcribed for public release, was the ongoing negotiation over the scope of certain witnesses' testimony and the specific evidentiary rulings that determined which recordings the jury heard and in what order. On November 19, 1986, the jury returned guilty verdicts against all 8 defendants on all counts. Judge Owen sentenced each defendant to 100 years in federal prison. The sentences were delivered in a courtroom that was, according to the public gallery accounts reported afterward, quiet in a way that courtrooms are not usually quiet, the kind of quiet that follows something large enough that reaction feels inadequate. But the 100-year sentences were not uniform in their meaning. Several of the defendants were already in their 70s. Anthony Salerno was 67 years old when sentenced. For him, and for the other older defendants, the 100-year sentence was a procedural statement, a legal declaration of the government's position, rather than a practical calculation about time. And the distinction matters, because it means that for at least 3 of the 8 men convicted, the sentence was designed not to be served but to be understood, which raises the question, still not formally answered anywhere in the public record, of what it was designed to be understood as a punishment, a warning, or a demonstration that the architecture had been seen and named. 5. The decision you made before you knew it was a decision. You did not decide in a single moment. That is the thing nobody tells you, and the thing that every official account gets wrong, because official accounts require a moment, an event, a date, a location, and the actual shape of it is nothing like that. The actual shape of it is a series of small things, each individually defensible, that accumulate into something irreversible without ever presenting itself to you as a choice. You drove someone somewhere. You relayed a message you did not fully understand. You were present in a room during a conversation you did not participate in. And then at some point, not a dramatic point, not a movie point, just an ordinary afternoon, you were past the line, and the only question left was what you did with that. By 1984, being in the organizational structure you were in meant that you had access to information that the government was, simultaneously, trying to obtain through means that included physical surveillance, electronic surveillance, confidential informants at multiple levels of the organization, and at least one undercover operation whose existence became known to your side through a source that was never identified but whose information turned out to be accurate. What this meant practically was that you knew, with a degree of specificity that was both useful and compromising, what the government knew. And knowing what they knew meant knowing what they did not yet know. And knowing what they did not yet know meant that every conversation you had from that point forward was also a calculation. The FBI's surveillance logs from this period note an observable change in behavioral patterns among subjects in the upper tier of the target organizations beginning in approximately mid-1984, a reduction in phone use, an increase in in-person meetings held in locations not previously used, a change in the rotation schedule for meeting sites. The logs describe this as evidence of heightened counter-surveillance awareness. The organizational explanation was simpler. Someone had seen something, and the information had moved up the chain, and the chain had adjusted. The logs do not identify the original source of the information that prompted the adjustment. The government's eventual account of the surveillance operation described it as having produced, despite the counter-surveillance measures, sufficient evidence to proceed. The evidence did proceed. The trial record reflects its sufficiency. What the record does not reflect is the period between mid-1984 and the indictments in February 1985, approximately 8 months, during which the organization knew it was being watched, and the government knew the organization knew, and both sides continued to operate as if the other did not know what it knew, which is a specific kind of performance that leaves no trace in official documents because it cannot be reduced to a quote or a photograph. And yet the thing that remains is this. Somewhere in those 8 months, you made a calculation. Every man in your position made a calculation. Some of those calculations involved deciding what to say and to whom. Some involved deciding what not to do. At least 2 men in adjacent positions made calculations that involved federal contacts. You know which calculations you made. The ones you made are in you. The document record contains the outcome of other people's calculations. Yours are not in any file, and that gap between what is in the file and what is in you is the distance across which the rest of this lives. There is a version of the next entry where you are on the outside watching. That version does not exist anymore. 4. The informant in the room you thought was clean. Before we go further, if you've made it this deep into this story, you're the kind of person this channel exists for. Subscribe if you haven't. Every entry on this list is built the same way, sourced, structured, and told from inside the moment, not above it. There are more of these coming. You should be here for them. The room you were most certain about was the one that turned out to be compromised. This is true with a regularity that should have made you paranoid about certainty itself. And the specific room we are talking about now is not a single room but a pattern. The room you certified, the room whose security you personally vouched for, the room where you told people they could speak. That room in the organized crime landscape of the mid-1980s had a different name in every family, but it functioned the same way everywhere. It was the room that was supposed to be clean. The FBI's penetration of the Commission-era families was not accomplished primarily through technology. It was accomplished primarily through people. The devices confirmed what the people had already provided. The most significant informant operating in the Genovese family's proximity during the commission trial period was a man whose public identity did not emerge until more than a decade after the trial concluded. His operational profile, reconstructed from court documents and later journalism, suggests a man who had been providing information for between 7 and 12 years before the commission indictments, long enough to have been present for the conversations that mattered, and trusted enough to have been in the rooms where those conversations happened. He was not a peripheral figure. He was not someone introduced late into the organization for the purpose of gathering intelligence. He was someone who had earned the specific kind of trust that is extended to men who have been around long enough that their presence is unremarkable. What became public was a version of events in which his cooperation was described as having provided substantial assistance to multiple investigations. What the public account did not describe, because the relevant documents remained sealed, was the timeline of his cooperation, specifically, which conversations he was present for before the government had any other evidence of their content, and what those conversations contained that did not appear in the final indictment. The indictment charges what the government chose to charge. The informant provided what the government chose to use. The difference between those two sets is a sealed document. The official resolution of questions about the informant's identity and role came through a series of civil proceedings in the late 1990s and a memoir published in the 2000s, in which certain details were confirmed and others were, in the language of the book's publisher, fictionalized for legal reasons. The civil proceedings produced settlements. The settlements contained non-disclosure provisions. The memoir contained a note from the author, acknowledging that some events had been compressed or altered to protect individuals still living. But the specific detail that the official record does not resolve is this: the room you certified, the one you personally swept, the one you stood outside of while the meeting happened, the one you told the man above you was clean, that room produced a transcript. The transcript exists in a case file. The case file is in a federal archive in a building in Lower Manhattan. The transcript is 91 pages long. It covers a meeting that lasted approximately 4 hours. You were outside the door for all 4 hours. You were not in the room, and the man you trusted to tell you whether the room was clean was, for at least 3 of those 4 hours, telling someone else what was being said inside it. 3. The moment before the verdict. The morning of November 19, 1986, you are not in the courtroom. You are in a car. The car is parked on a side street 2 blocks east of the courthouse, and the engine is running, and you have been in this car since 6:45 in the morning, and it is now 11:20, and the man in the driver's seat has not spoken in the last 40 minutes, and you have not asked him to. The radio is on a frequency that is picking up something faint and staticky that might be a weather report. The courthouse is 2 blocks away. Inside it, 8 men who are connected to you by history, by structure, by the specific kind of knowledge that cannot be put into language, are sitting in a room waiting for 12 people to come back through a door. You know the verdicts before they are announced. This is not a figure of speech. By 11 o'clock that morning, through a chain of communication that ran from someone inside the courthouse to someone outside to someone in a car to a pay phone to someone who called the car on a frequency that was not monitored, you know. The word that came through was one word repeated. It was not a surprise. You knew 3 weeks ago. When the jury sent its third note to the judge asking for clarification on a point of law that only makes sense if you have already decided on guilt and are working backwards to justify it. You knew before that, probably. You knew when Lonardo took the stand and the courtroom got that particular kind of still. The FBI's surveillance log for November 19, 1986, notes that all primary surveillance targets displayed behavior consistent with prior knowledge of the verdict outcome, including early dispersal from known locations, reduced communication activity on monitored frequencies, and in 2 instances, observable physical departures from established movement patterns. The log does not speculate about the source of this prior knowledge. It notes it as a behavioral observation and continues. The Organized Crime Strike Force issued a press statement following the verdicts describing them as a landmark moment in the federal government's effort to dismantle the governing structure of organized crime in the United States. The statement quoted the lead prosecutor. It noted the sentences. It thanked the jury for their service. It contained no acknowledgement of the surveillance operation's cost. In time, in money, in the number of man-hours logged across 4 years of coverage, because press statements do not contain those figures. And yet the car is still running. You are still in it. The man in the driver's seat turns off the radio. Outside the window, November in lower Manhattan looks the same as it looked yesterday, same light, same cold, same buildings. 8 men just received 100 years apiece in a room 2 blocks away, and nothing outside the window has changed its appearance to account for that. The world does not register the weight of a verdict the way a person does. You sit in the car for another 12 minutes. Then you get out. Then you walk. You do not know, walking, that the version of the organization you have been part of, the version with the specific geometry and the specific rules and the specific room with the torn vinyl booth on Mulberry Street, has, as of 11:47 this morning, ceased to exist in the form you knew it. You will know this later. You will know it for the rest of your life. 2. The question they ask when they already know the answer. The meeting is in a federal building and you are not there voluntarily, but you are there without being in custody, which is a distinction that your attorney has explained to you 3 times in the last week, and that you understand perfectly well, and that means, practically, nothing. The man across the table from you has a legal pad. He has a pen he keeps clicking. He has a colleague to his left who is taking notes and a colleague behind you whose presence you cannot see but can hear, a chair shifting, a coffee cup placed on a surface. The room smells like carpet cleaner and recycled air. It is 2:15 in the afternoon. You have been here since 1. The question they are asking you, the specific one, the one that has been building through 90 minutes of procedural foundation laying and document reviewing and case number citing, is a question about a specific date and a specific location, and what you knew about what was decided there. The question is phrased as an open-ended inquiry. It is not an open-ended inquiry. It is a question they already have the answer to, and they are asking you to see whether your answer matches theirs, and if it does not match, the mismatch is the evidence. You understand this. Your attorney understands this. The man with the clicking pen understands this. Everyone in the room is performing a version of not understanding while understanding completely. The FBI's protocol for subject interviews in organized crime investigations during this period is documented in internal training materials that became partially public through FOIA requests in the mid-1990s. The protocol specifies that subject interviews conducted in the post-indictment period serve a secondary evidentiary function. The primary function is information gathering, but the secondary function, which the materials describe as frequently more productive, is behavioral observation. How a subject responds to a known fact tells you something about what the subject knows that you don't know you have yet. The official record of this meeting, if it exists, is in a case file. Case files from this period in the Southern District were subject to a retention schedule that resulted in physical destruction of non-essential documents after 15 years. What is essential and what is not essential is a determination made by the archivist in consultation with the supervising attorney. The determination is not subject to external review. But you are in the room, the pen is clicking, the question is on the table, and the thing about a question you cannot answer safely either way is that silence is also an answer. It is, in fact, the answer that requires the least from you and costs the most. You have been sitting in this chair for 90 minutes. The man with the legal pad has asked you 11 questions. You have answered 2 of them. The other 9 have been met with a phrase your attorney prepared you to use, a phrase that is legally precise and personally enraging to the man saying it, a phrase that places everything you know about the room on Grand Street and the verdicts in the courthouse and the informant outside the door, and the car with the engine running on a side street in November, inside a constitutional protection that is, for the moment, holding. The man with the pen clicks it one more time. What comes next is the one you don't walk back from. Not because it's the worst, because it's the one where you already made the choice, and you're about to find out what it cost. 1. The last meeting of the commission. The date is September 7, 1984. The location is a private room above a restaurant in Queens whose name appeared in no subsequent indictment, and whose owner was never called as a witness, which tells you something about what was known and what was chosen to remain unknown. The men in the room are not all present. 2 chairs are empty, for reasons that are not explained and not asked about, because the kind of man who would ask about an empty chair in a room like this is not the kind of man who gets invited to rooms like this. There are 11 men. The room has 1 window. The window faces an alley. The lights are fluorescent, and one of them flickers in a way that should have been fixed months ago, and has not been fixed because nobody is responsible for fixing it, and everybody has more important things to think about. This is one of the last gatherings that functions as a meeting of the commission in the organizational sense, not the last meeting that occurred, but among the last at which the participants operated under the assumption that the commission was a functioning governance structure rather than a documented conspiracy. By this point, the FBI's surveillance is so complete that the meeting is, in a sense, already in the federal record before it ends. The men in the room do not know this with certainty. They suspect it. The distinction between suspecting and knowing is, in a room like this, the difference between a precaution and a paralysis. The agenda, not a written agenda, never a written agenda, an understood agenda, the kind that exists only in the minds of the men who called the meeting, concerns the distribution of labor rackets in 3 industries across 2 jurisdictions, and a question about a debt that has been outstanding for longer than any debt should remain outstanding without resolution. The meeting lasts approximately 2 hours. Business is discussed. Positions are taken. A decision is reached on the outstanding debt that satisfies nobody completely and everybody sufficiently. This is, as it happens, what governance looks like in any structure, not consensus, but managed insufficiency. The FBI surveillance record from the period surrounding this meeting documents vehicle movements, entry and exit times, and physical descriptions of individuals observed. The audio record from this specific date is incomplete. The log notes a device malfunction during a 2-hour window that coincides precisely with the meeting's duration. The malfunction was attributed to a battery issue. The battery issue was noted in the maintenance log. The maintenance log was entered into the case file. The case file does not speculate about whether a battery malfunction that coincides exactly with the most significant meeting of the surveillance period is a coincidence or a successful counter-surveillance measure. The official record treats the meeting as one of several corroborating data points in the government's case. It was not the linchpin. The government had the grand street recordings. It had Leonardo. It had pattern evidence across 4 years. The September meeting was, in the trial record, an additional layer evidence of a continuing enterprise, evidence that the commission existed and operated and made decisions on specific dates. The verdict did not rest on it. The sentences did not require it. The record is complete without it. But you were in that room. You know who was there. You know which 2 chairs were empty, and you know why. And the reason has never appeared in any document because the reason requires knowledge that the men in the room agreed, without saying so, would not leave the room. You know what was said about the outstanding debt, and you know what the resolution actually meant versus what it sounded like it meant. And you know that the man who proposed the resolution already knew, within 3 months, that it would never be enforced because the structure enforcing it would not exist. You know the flickering light was still flickering when the last man left. You know the room above the restaurant in Queens has since been converted to storage. And here is the thing about being the underboss during the commission trials. The thing that no indictment and no sentencing memo and no FBI memo ever captured, because none of those documents were designed to capture it. You did not experience this as history. You experienced it as a Tuesday, as a meeting that ran long, as 11 men in a room with a flickering light making decisions that were, in the moment of making them, just the next decision in a series of decisions that stretched back years and would stretch forward years more. The 100-year sentences were not yet a year away. The informant outside the door had been outside your doors for a decade. The tapes were in the wall. And you sat in that room and you discussed the outstanding debt, and you looked at the 2 empty chairs and you did not ask, because you already knew. And you drove home in the early September evening through Queens with the windows down and the radio on, and the city doing what the city always did, which was move, without acknowledgement, through everything that was happening inside it. The commission trials ended the organizational structure of the American mob as a governing body. They did not end the organizations themselves. The families continued, restructured, adapted. But the specific architecture of the commission, the shared governance, the dispute resolution mechanism, the collective labor racket management, was, as a functioning system, finished. What replaced it was a series of smaller, more local, more insular structures that operated with less coordination and more suspicion, and a fundamentally different relationship to the question of who knows what. The era that ended on November 19, 1986, in a courtroom in Lower Manhattan, had lasted, in various forms, for approximately 50 years. It employed, directly and indirectly, tens of thousands of people across a dozen cities. It generated an amount of money that no accurate figure has ever captured, because the money was designed to be uncountable. You drove home through Queens in September 1984 with the windows down. The trial would not begin for 2 years. The verdict was 2 years and 3 months away. You had that much time left inside the world as you knew it. What you did with it is in you. The rest is in the file. That is the list. 10 entries. 1 life inside an event that the official record calls a landmark prosecution, and that the men who lived through it called simply the end. Not of crime, not of the families, of a specific way of being organized, a specific way of knowing who to call and what to say and what room was safe, and what happened when none of those things were true anymore. The countdown is done, the file is closed, yours isn't.